You're watching The Legal Breakdown. All right, so Glenn, we've got Trump aides and lawyers issuing their pleas in court right now. Walk us through what just happened in the Arizona indictment.
Yeah, Donald Trump's lawyers just can't stop getting indicted. So there was an indictment brought out in Arizona against 18 co-defendants. Basically, all of the folks who participated in the fake elector scheme out there, including some Donald Trump lawyers, with the goal of trying to help Donald Trump steal the 2020 election. So yesterday, we had the last few defendants actually walk into court, and those defendants included Trump lawyer or former lawyer Boris Epshteyn and Trump former lawyer Jenna Ellis. I do think Epshteyn and Ellis sounds like probably the world's worst law firm at this point. They walked in, they pleaded not guilty, and they have now joined their 16 fellow co-defendants. And recall, there are some big fish indicted out in Arizona, people like Mark Meadows and Rudy Giuliani. So it is a pretty consequential case that has been brought, 9 felony charges in all. And, now we'll see what the next steps are out in the Arizona prosecution.
Real quick, Glenn, did all of the co-defendants here plead not guilty?
They did, and that's exactly what we would expect. Why? Because the first hearing in the case is what's called the arraignment hearing. And that is when the defendant first gets formally notified of the charges on which they've been indicted. So what nobody ever does at an arraignment hearing is walk into court and plead not guilty, because they're only learning for the first time the nature of the charges. They don't have the discovery yet, that is the evidence that the prosecution will ultimately give them. So nobody walks into court on day one and pleads guilty. So that is exactly what we would expect from Jenna Ellis, Boris Epshteyn, and all of the other co-defendants.
Well, that leads me to my next question, because Jenna Ellis is cooperating in the Georgia indictment. So my assumption here was that she would cooperate in other similar indictments, since the charges against her would likely be the same. The case that would be brought against her would likely be the same. So do you expect that she will eventually change her plea here from not guilty to guilty if and when she decides to cooperate?
Yeah, great question. Let's tease that out a little bit, because in Jenna Ellis's first court appearance, her arraignment in Georgia, just like in Arizona, she walked in, pleaded not guilty, and then she changed her plea. She pleaded guilty. She not only admitted to committing the crimes down in Georgia to try to help Donald Trump steal an election, she agreed to testify truthfully against Donald Trump and any other co-defendant in whose trial she might be called as a witness. So there were two things going on in Arizona. First of all, as we just discussed, it's not surprising she walked in and pleaded not guilty in Arizona. What she might have done is met with the Arizona authorities in advance of yesterday's arraignment hearing to see if they could bang out a cooperation agreement that would result in her not even being indicted in Arizona. Listen, if I were the Arizona prosecutor, I would have reached out to Jenna Ellis's lawyers and say, look, she already pleaded guilty and is cooperating down in Georgia. It only makes sense for her to enter into what we call a global resolution or a global disposition, where a defendant who's facing charges in multiple jurisdictions essentially pleads guilty in all jurisdictions and then gets the most benefit for her bargain, right? She will cooperate in all jurisdictions. So it was a little surprising that she didn't, enter into those kind of negotiations with the Arizona authorities such that she wouldn't even have been an indicted defendant in Arizona. Apparently that didn't happen, and that could be for a number of reasons. It could very well be that the Arizona authorities didn't want to show their cards at all to anybody, including Jenna Ellis's lawyer, before they brought charges against all 18 co-defendants. But just as you suggest, Brian, I now expect the Arizona prosecutors will hunker down with Jenna Ellis's criminal defense attorneys and see if they can reach a similar plea agreement with cooperation, just as Jenna Ellis entered down in Georgia.
Well, I know folks are going to be watching this, and they're going to look at someone like Jenna Ellis, who may very well engage in yet another cooperation deal with prosecutors and feel like she'll be let off the hook then. Does she have any legal exposure, even if she does opt ultimately to engage in some type of a cooperation agreement with prosecutors?
Brian, absolutely. I would never give away the farm. I would never tell somebody, listen, you plead guilty. You accept responsibility for the crimes you committed as part of this criminal conspiracy with Donald Trump and others to steal a presidential election, and you won't be held accountable at all. You won't have to serve a day in jail. The problem with that, Brian, is if you give away the farm, when you put a cooperating witness like that on the stand and you sponsor her testimony and you have to, try to present her in credible fashion to the jury, the jurors are likely to say, wait a minute. You gave that defendant a pass. That defendant is going to say anything you want her to say that will incriminate my client because, they are beholden to you because you didn't hold them accountable at all. That's why, it's always a tactical challenge deciding, okay, how much of a benefit do I want to give a Jenna Ellis to bring her into the fold and have her testify credibly as a cooperating witness in the criminal trials of others. So, very rarely, Brian, prosecutors will find ourselves in a position where we so want that person's incriminating testimony about bigger criminal fish, we'll give the person immunity. And we will give them, in essence, a pass as long as they agree to testify truthfully about others. But what's important for people to know is if you grant somebody immunity and you put them on the stand to testify in the trial of a bigger criminal fish, if they lie, then their world comes crumbling down on them because even though they got a free pass up front with the immunity, they can be charged with perjury. They can be charged with accessory after the fact. They can be charged with obstructing justice. So that's how we try to keep their incentive high, even if we give them immunity, to tell the truth when they're testifying against others.
Now, Glenn, I know that the arraignment happens quickly, and then there's a lot that goes into the pretrial period before we actually go to trial. But is this process moving more or less quickly than usual, or is it moving at about the same pace that you would expect?
Once the indictments were returned by the Arizona grand jury, things are moving along as you would expect. Now, there has obviously been a long delay since these crimes were committed back in, late 2020 into early 2021. So the Arizona authorities took a very long time, in my opinion, to investigate and indict the 18 co-defendants. But now that they're in court proper, the Arizona speedy trial laws will kick in. And every jurisdiction is different with respect to the time frame by which a prosecutor has to bring a case to trial. But here is really the inside baseball about speedy trial rules and laws. They can be waived by the defendant. So prosecutors are often pushing for a speedy trial, even more so than the defendants. The defendants want to take all the time, kind of win all the delay they can before they ever have to go to trial. So all it takes, Brian, is for a defendant to say, I waive my right to a speedy trial, and then things tend to slow down.
And do you think that the co-defendants here, because of their links to Donald Trump, are going to do everything they can to delay so that they can try to seek some remedy by virtue of Donald Trump winning the election, even though, of course, there is, the distinction between state crimes and federal crimes? Donald Trump can't pardon people for state crimes, but we all know Donald Trump. He doesn't care what he can and can't do. He's going to try to do it anyway. So back to the initial question, do you think that they're going to try to seek some type of delay in the same way that Donald Trump is seeking delays in all of his trials?
Absolutely, because really their best opportunity to escape responsibility completely for the crimes they pretty clearly committed to try to keep Donald Trump in power, their only hope of completely avoiding accountability is for Donald Trump to get elected president again. And then with the awesome power of the presidency, there is quite a bit of mischief he can make in state court proceedings and prosecutions and cases. Whether he could do it in a way that is supported by the law or in a way that violates the law to Donald Trump, I don't think that makes a whit of difference.
Yeah, I think that's spot on there. Well, we will, of course, stay on top of this trial as it continues to progress, as well as the other prosecutions that are ongoing right now. For those watching, if you want to follow along and you're not yet subscribed to both of our channels, please go ahead and subscribe. The links to both of them are right here on this screen. I'm Brian Teller Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.